Good morning, everyone. Thank you very much for joining us bright and early for Aitken Partners Business Law Breakfast, our final one of the year. My name is Imogen Timms, and I'm a lawyer at Aitken Partners. Today, I'm joined by my colleagues, Bianca Mazzarella and Christine Roberts, to discuss all the new psychological health regulations, which from 1st of December will be coming into play. They significantly raise the bar of how employers need to prevent, manage, and eliminate psychosocial hazards. Our first panellist, Bianca Mazzarella, is an employment lawyer and a member of our litigation team. Her sharp expertise across all facets of employment law and workplace relations is complemented by a friendly disposition and commercial approach that has underpinned her ability to build long-lasting client relationships. Bianca is a passionate lawyer who is well versed in managing disputes in the employment and workplace health and safety arena. She enjoys defending and representing clients at conciliations tribunals in all federal and Victorian courts and tribunals. Bianca is a persuasive advocate who has the ability to provide strategic advice to clients, focusing on their desired outcomes. Bianca also has extensive experience working with employees and employers on a variety of complex employment matters. Bianca drafts employment agreements, workplace policies, contracts, conducts investigations into claims of discrimination, harassment, and bullying, and assists employers to manage performance issues in the workplace, such as terminations, redundancies, and transfers of business. Bianca frequently assists employers in relation to compliance with workplace legislation, privacy obligations and contractor agreements, employee entitlements, and award disputes. Our second panellist, Christine Roberts, has worked in the legal industry for nearly 40 years, all of it with Aitken Partners in a variety of roles. She's presently the firm's HR and office manager and brings a practical approach to the position, having been a law clerk and administrative clerk in the prior years. She is passionate about supporting Aitken Partners lawyers and experienced administration staff to provide high-quality service to our clients. She strives to understand individual needs and has played an important role in the development of the firm's warm and inclusive culture. If you'd like throughout the session, please put any questions you've got into our chat box. But Bianca, to get us started, what's going on these reforms?
Thanks, Imogen. I think we've seen over a number of years now that statistics have shown that mental health is a real issue in the workplace. And workplaces are readily accepting that mental health issues and injuries are just as important as physical ones, even though they obviously can't be seen. Some of the statistics recently that have come out is that there has been a 30% increase in mental health claims from 2017 to 2018, and staggeringly a 97.3% increase over the last 10 years. And we've also seen that the amount of compensation for mental health injuries is quite high. So we've got on the screen there 64,400 for mental health claims versus 43,300 for injuries to nerves and spinal cord, which is obviously quite a serious injury. And interestingly too, the median time lost for mental health injuries is 35.7 weeks versus 15.3 weeks for injuries to nerves and spinal cord. So again, quite high. We've seen that the cost to employers is very high, and those that leave or take time off whilst undergoing mental health issues often don't return back to work, or the percentage is quite high.
So given this background, how's the law going to change?
Yeah, so the law, I think a lot of people think, well, the regulations are something that are brand new and something completely new. They're not. They just build upon the OH&S Act, which is already there, which already provided employers with the duty to provide a safe working environment for all employees and to eliminate risks in a workplace where possible. What the regulations do is they define what psychosocial hazards are in the workplace, which I know Chris will speak to shortly. And they also speak of or define the hazards as factors in work design, management of work, systems of work, carrying out of work, personal work interactions that cause the experience of one or more of a psychological response. So we're really just defining what they are better and clarifying what the duties are for employers.
Chris, you've been in the HR game for a very long time. What are some examples of psychosocial hazards?
Sure. And yes, I have been. So perhaps let's start with what is psychosocial hazards, just to explain the purpose of this morning's meeting. And they refer to factors in the workplace or environment that can cause stress or affect a person's mental or emotional well-being. These hazards often stem from interactions, roles, work environment or organisational culture, rather than just physical risks. Some of these examples include bullying, harassment and aggression, including gender violence, remote or isolated work, poor communication, support or relationships, intense or sustained high mental, physical or emotional exertion required for the role, unachievable deadlines, unrealistic expectations to be responsive outside of work hours, and that right to disconnect was a really important factor of that was introduced last year. Exposed to traumatic events or content is a real issue for a lot of people with client-facing roles. Poor training tools and resources and a lack of clarity for the role or for some of it, low job control or demands. And so these hazards are significantly impacting employees' mental health and overall productivity if not addressed, leading to burnout, depression, anxiety, or even physical health issues due to the stress they are experiencing. And I know, Bianca, you recently conducted a survey.
Yeah.
Had some findings with your clients.
Yeah, thanks, Bruce. The most the psychosocial hazards that are occurring most predominantly in the workplaces appear to be, I think, unsurprisingly, bullying, harassment, aggression and violence, and poor organisational change. I also wanted to add that there's a Commonwealth Code of Conduct, which is federal, and that's also included or added to the definition of psychosocial hazards, fatigue. Which I think is topical given COVID. You know, people often think that people work less when they're from home. Depending on your role, you can actually work more and not really turn off that much, always checking devices, which can result in fatigue. Another interesting one is intrusive surveillance. Again, I think interesting from COVID. I think employers got a bit nervous when people were working from home. They wanted to really monitor them. There's even, some employers that were doing keystroke analysis that was found to be, very intrusive and psychosocial hazard. People getting quite stressed about that, which is understandable. And also job security. So telling people, you don't do that job, you're replaceable, those sorts of things. So I think that's really interesting that that's been implemented at a federal level as well.
So given we now know what a psychosocial hazard is, then what do employers need to do now to comply with the regulations?
Yeah, I think it's really clear. So now we need to identify and assess what the psychosocial hazards are as far as reasonably practicable, eliminate, or if you can't completely eliminate, reduce the associated risks, again, as far as reasonably practicable, and review and revise the risk control measures regularly to ensure that they're implemented correctly and that they, in fact, remain effective.
So what does that look like in practice?
Yeah, sure. So good question. So identify and assess. Really what we're seeing workplaces do is analyse their different departments, meetings with managers, managers then meeting with employees to discuss these issues so that psychosocial hazards can be brought up in a safe space. Also reviewing data, so things like looking at patterns with employees. So, for example, it might be, a particular department has lots of people leaving. Why is that? In their exit interviews, do people say things like, look, there's too much work and I'm really stressed? So analysing that kind of data. Also absenteeism, workers' compensation, any trends with employers' complaints, things that people bring up. Anonymous reporting channels, I think, are really good, so that people feel comfortable bringing up these sorts of issues and without any fear of any kind of adverse action being taken against them in response. And meetings with mentors, I think, is a good one, where people often feel more comfortable not in a big forum, but on a one-on-one to actually raise issues. So that's the first step, identifying and assessing, and there's some sorts of things that you can do. to eliminate and reduce the risk of psychosocial hazards. There's an onus on the employer to control the risks, and that might involve modifying work design, systems management, environment, equipment. I spoke about overwork before. So say your organisation identifies that there's people that are leaving because there's too much work, there's overwork. They might try to combat that, and they might not be able to completely eliminate it, but they might be able to reduce the effects of it by hiring additional staff. Also, automation of some parts of roles might take the stress off. AI is obviously a big one now. And another one might be, for example, might be in schools that you might have, aggressive students, aggressive parents, or you might have companies that have aggressive clients. And so having workplace policies to deal with those difficult stakeholders. And what employees can do to implementing policies so that employees know what they can do if they find themselves in that position to reduce the effect. And I think a key point here is under the OH&S Act, I think there was a misconception that all you really had to do was have some policies, have some training, and you were done. You ticked off on that. The new regulations are really clear that, look, if that's the only thing that's actually possible, sure, like you should do that. But, the WorkSafe and the regulators are not going to look favourably on your business if that's all you've done. You've had some policies and you've done some training. You really need to actually go in there, get your hands dirty and identify those hazards, reduce and eliminate. And then the last step is you've got to review and control those measures. So it's simply not good enough to have a policy, put it in your drawer, not look at it. The company or employers have to be really mindful that they have to make sure that they constantly review to ensure that they remain effective. Things change in organisations all the time. Things that, might sort of alert an employer that you need to, review processes are, there might be new information that arises. There might be redundancies, new setups. There might be, a new type of psychosocial hazards that's reported. There might be a notifiable incident. Public Safe rep might request one. So just always keeping up to date. And the WorkSafe psychological compliance code is really helpful for assistance.
So what happens if an employer fails to follow those 3 steps?
Yeah, good question, Imogen. So Section 21 of the OH&S Act is pretty clear. So if an employer fails to provide a WorkSafe that is safe and without risk to health, there are penalties. The penalties can also lead to criminal charges, and that's why regulators often prosecute these matters. And it can also lead to, prohibition notices, improvement notices, that sort of thing. But it'll be interesting to see how it plays out and what kind of penalties.
And Christine, from an employer perspective, what resources can you rely on to help you follow the new regulations?
Sure. I think Bianca touched on it just earlier. The WorkSafe Psychological Health Compliance Code is really a source for employers to look at the actions that they need to comply with to meet the regulations. And also, we should say that this isn't mandatory, but it's certainly a practical approach and for examples for employers to show how they can meet the regulations. Appendix B of the code explains how employers can collect data on the hazards such as disrespectful or harmful behaviour. And that's quite broad, but obviously with different industries that has different levels of stress for people. It's also important to know that the code can be used in court as evidence. Working here with lawyers, that's really relevant. And certainly how these hazards can be relied upon by the court to assess whether the employers are meeting these standards. And just to know that this document is 112 pages long, but it certainly is worth keeping on hand for all managers and employers of businesses. And WorkSafe also have a prevention plan available to all employers, which allows us to evaluate our own code of conduct in our businesses and to evaluate any current or emerging risks that might be happening in the workplace. So I like to think it as an insurance policy. It's if a hazard arises, you have the plan in place, and then you can refer to it and know who to, what parties or senior members can be involved in supporting that risk that you're working with.
I think the prevention plan is really important one, Chris, because earlier in the year we thought that the regulations would mandate employers actually having to submit the prevention plans that they have to WorkSafe and also the complaints that they receive. Like Chris said, it's not mandatory, but it is something that is like an insurance policy that you can fill out, actively show that you've identified hazards, that you've done everything you can to eliminate, manage, that you're circling back as to, okay, when's that due? Should we have done that? How's that working? So that if a claim is ever made, you can actually bring that out as evidence to show that you've done something about it and you haven't just sat on your hands. So I think that prevention plan is, underestimated and certainly a good thing to have on hand.
So let's change some recent cases. Fiona, can you walk us through what happens in Matthews and Winslow?
Yeah, these sorts of cases, the reason that I'm discussing these is they're extreme cases, and sort of a bit of a warning that we do talk about some sensitive issues. So if you do need to, tune out or log off for a bit, we completely understand. My hope is that in discussing these cases, the issues will be so obvious to you that hopefully if they ever happen on a lesser scale, you'll be able to readily identify that they, may be an issue and that something should be done about it. So in Matthews and Winslow, Kate Matthews was a labourer. She was subjected to daily comments about her physical appearance, about her body. They would say, awful things to her. Some of the words spastic, bimbo, useless. Saying to her, one co-worker, I'm going to follow you home, rip off your clothes and rape you, like some horrible derogatory comments. There was actually no complaints handling policy or procedure. Kate didn't know really who to go to about it. She reports it to her area manager. They don't really do anything about it. She then finds somebody in HR to report it to. And he says to her, oh, why don't you come over to my house? Let's have a drink and we'll talk about it. So hopefully there's some real red flags, standing out there. But ultimately, she was awarded $1.3 million in the Supreme Court. She suffered, some serious depression and other issues. Even some of the conduct that I've described, I understand, is not some of the worst conduct that occurred, which is just pretty horrific. So, yes, I might leave it now to Chris to maybe discuss what the employer should have done.
What they should have done. And clearly you mentioned that there was no policies in place. So this is probably where we first start with is implementing gender equality policies, particularly if you've got a predominant male workforce and you've got one single female. So it just shows how critical that was. Establishing clear reporting procedures and ensuring staff are trained to use them as well. And I think you touched on before, having a key contact to report to. And unfortunately, that person also let this particular individual down by further derogatory comments about coming back to their place. So really unfortunate. And I think you need multiple key contacts for that reason, because the perpetrator might be the person that is the key contact person, which makes it very hard to report. Provide the staff with support and supervision in these instances, because clearly that was warranted in these cases.
Yeah, there were lots of people on site all the time. They saw this conduct occur, but nobody did anything about it. So I think, training managers about what's expected of them and what they need to do if they see a psychosocial hazard. Yeah.
Absolutely. And just clearly in this instance, regular training for the managers and the staff. And that must be regular because staff come and go. So you need to be able to make sure that this so code of conduct, particularly in this instance, is and for other businesses as well, is certainly a regular thing to maintain and reduce that risk.
And what about the case of doulas in the state of Victoria?
Yeah, this was an interesting one, and I think I mentioned before. You know, you can think of this is about a school, so we're dealing with students and potentially parents as well. But if you're an organisation that you're not a school, you might think of clients as the, you know, to replace the students with the clients. Peter Doulis was a teacher. He was assigned classes with students with high level of needs. They called them, I think, foundational low classes. He experienced a lot in those classes. So, you know, there were, you know, things written on the whiteboard. There was a flamethrower, I think, in the class. You know, when he reported the issues that were happening in class to the principal and the assistant principal, they really just said there must be an issue basically with your teaching. He had some time off. There was never any, you know, independent medical examination ordered when he came back to make sure that he was fit for work. He requested that next year he not have so many classes with these types of students. That it'd be spread out. The next year, he sort of got the same level of those classes. You know, there was, you know, students making the throat slitting gesture to him. He would often break down in the locker room. Teachers would see him cry. The principal would, you know, attribute it to personal issues that must be at home. He had suicidal thoughts. There was no pathway to raise complaints. And so ultimately it was assessed by WorkSafe. He couldn't return to work. He got diagnosed with a major depressive disorder. He tried to commit suicide on a number of occasions. And so, yeah, it was horrendous, in fact. And ultimately that led to, you know, the employer being in the spotlight. Sorry, Imogen, I'm taking over your question here, but I think it's over to Chris now to talk about, you know, what the employer should have done there.
Yes, so it's interesting because we're dealing with the state government program here, and some of our clients here are private businesses. So, but the rules still apply, and that's the most important thing here. It doesn't matter what your body is, and in this case, there's a lot to unpack here, but the request to not have so many classes in the following year was ignored. And so, unfortunately, that added to the stress of this teacher, and that therefore allowed that issue and that risk to carry on. There was no independent medical assessment done or offer to this employer to make sure that they're suitable to deal with such challenging students. I think it's also they didn't even recognise that he may have needed support in the classroom. Now, that could be through a teacher's aide. You don't know what's behind you when you're dealing with another issue with a challenging student. So that's something that they could have done to support and help. Counselling. I think that was really important. They're ignoring, there was no reporting avenue for this person. There was no training. And I think that if you're seeing a teacher crying in a classroom, the first reaction is to check in with any employee, just to make sure that it's not work-related. If it's personal, that's a different conversation. But maybe direct them to take some personal leave and some sick leave if they're struggling with that as well. And just check on their wellbeing. I mean, that's just so critical. That's what we hear about here today. It's reducing those hazards and making sure that the wellbeing is the first importance when we're dealing with our staff. And the complaint policy we talked about, there wasn't one. And where appropriate, these students, were they disciplined? But perhaps they should have been suspended or expelled as well, because it's not okay for it all to be the blame of the teacher.
It's just a question from online, just to follow up with that, Christine, from an HR perspective. What role can an EAP play for businesses?
Sure. It's something that we always offer our staff if they're struggling with different layers or levels of stress, because sometimes it's hard to talk to your own managers or line managers at work. So it's really good to have an external perspective. So we always offer that to our staff. It's very important.
But yeah, moving to a slightly different context, let's move to mining. Mobile management has taken on a pretty hefty and forceful undertaking after some not so good behaviour. Can you walk us through what happened that ended up bringing on the undertaking, what they could have done to prevent that undertaking needing to be put in place?
Yeah, so Crowbar management, Crowbar was an interesting one. They had a workplace where they had some senior managers located in Switzerland, so different time zones. You had 2 accountants in this one who had unclear job roles, lack of support, excessive workloads. They were working ridiculous hours, so like 9 a.m., then they'd be working till 3 a.m. and then up again at 9 a.m. to deal with the different time zones. Obviously touching on, what they could have done is having policies about time zones, addressing that overwork, fatigue, and they had some really aggressive managers in place. Sometimes that can happen when you've got so many different generations in one workplace. So there can be a bit of a mentality of, well, in my day, I would have just done it and, not complained. And we saw earlier in the statistics the increase in mental health, increasing 97% in the last 10 years. So for some generations, it was just simply something that wasn't really acknowledged as I can't see it, I can't see the injury, so it's not there. So, yeah, I think there should have been greater role clarity as well in terms of what they could have done. An interesting one in Crowbar management is at the outset, they actually did do an investigation about, some issues in the workplace. But they did nothing about it. So they ticked the first box in terms of identifying, but then didn't do anything about it. And I think they were heavily scrutinised by that for not acting on previous advice and reports, given they were aware of it. I think talking about the different generations, training managers, that have a different mentality. Some people have said to me in terms of discussing this topic, well, they're actually the problem, the managers. They're perpetrating this issue. What do we do about that? How do we make them take notice? And I think it has to come from the top. Discussions around, this is important, this is legislated, there are penalties if we don't do it. Aside from that, it has a big impact on our workplace culture and profitability if we don't do anything like that. I've seen some places put managers addressing psychosocial hazards in their KPIs, which can then negatively affect their performance if they don't tick off on it. So I think that's a good one. There's even consideration of bonuses for people if they are, doing the right thing. So really, sometimes, money incentives speak to people, which I can understand. So yeah, I think that's a good one. And yeah, just those policies. So fatigue management, time zone policies, complaints procedure, and also just a quality at work policy, I think would be important in this scenario.
So Christine, bearing everything we've spoken about this morning in mind and noting we've only got 5 days until the regulations kick in, what are the key points employees should be focusing on as they're rolled out?
Sure. Act early. I think you said, Emmy, we've got 5 days to come into effect. And I think we all need to assess our own social risks that in our workplace. And Bianca mentioned this earlier. It's for HR. It's looking at absentee patterns, exit interviews. Why are people leaving? Is there a trend? They're really good reporting mechanisms for the businesses to assess, and also to prevent and look at why that's happening and make some changes. And then consulting with your staff and your line managers and the like. And one option is considering to use an anonymous survey, because that's a really good tool to spot some emerging issues that we may not be aware of. Adapt. Training. I think you touched on this before, Bianca. People, you tick that box but it's not just training and we can then just get back to work. It's really looking at your work design, your patterns, behaviours, trying to continually eliminate with online training sessions. Just doesn't stop. comply. We talked about that earlier. We've got till 1 December. We've got 5 days. And so get onto the WorkSafe website. They've got the prevention plans, really easy to use. It's a really good starting tool.
So again, what are your final tips for employees who are watching this now thinking, oh, how can I comply by the 1st of December?
Yes, well, I think consulting on all levels is important, not just consulting with managers or, other staff, but really making sure everybody is across it so that we're all on the same page and so that employees understand that the employer is taking it very seriously. Making sure that you observe changes in the workplace. I know that sort of sounds common sense, but it can invite a bit of trepidation if people see themselves, oh, it's not really my place, it's probably to do with something at home. If it's something that you see consistently, I'd be making sure you check in with people, and I think that's just good for workplace culture anyway. Something else that I think is undervalued is psychometric testing. So doing that, putting in a bit of work at the front end before you employ people. So there might be specific questions that can be developed by the company to see if you can ascertain what that employee would be like, what their threshold for certain things are, and also different types of personalities that they might be able to work with. And sometimes, you've got good employees, but they simply just don't, some don't work well with others. And that's fine. But seeing that from the start or identifying that from the start can prevent a lot of issues later. Like we said before, monitoring trends that you see in the workplace, long-term absentees. There's also a bit of trepidation about, directing people to attend independent medical examinations once they've been off from work for a while. I think that's really important for the employer to make sure that they are fit and healthy to return to work. They should get advice if they're feeling, anxious about doing that. So make sure it's done in the right way and included even at the front end, like in contracts. Yes.
So this is all a lot for employees to roll out, but also for them to continue to comply with. What services can we offer our clients to help them comply with these regulations?
Yeah, so I mentioned before, starting of employment agreements, make sure that, the wording talks about workplace policies in the right way and in a way that doesn't bind employers unless they want to be, which can be a fine balance. We can review and draft workplace policies. I do those sorts of things all the time. I think a lot comes out of it, when you actually go through the process and talk to the organisation about what they're seeking. It's not good enough in my view just to have some sort of boilerplate policy that's been found online. It really needs to be tailored to the organisation. And I think the new regulations will be critical if organisations don't. We talked about workplace surveys, so we can assist in designing workplace surveys, conducting spot checks. We can also conduct investigations where there's no conflict or brief investigators to help identify psychosocial hazards at the outset, and then we can get involved in terms of providing the organisation with recommendations about what we need to do to eliminate and reduce. Again, I think that's a really good insurance policy. We saw that in COBAR management, they had that, but they didn't do anything about it. So doing that at the outset, but then actually acting on recommendations where appropriate. Obviously, we hope that none of our clients end up in a prosecution, but we can obviously assist with prosecutions if need be and assist with workplace health and safety queries about, in the early stages, we have a complaint. What do we do? Those sorts of things. And another undervalued one is, sometimes disciplinary action does need to be taken against employees, and employers can be quite fearful of doing that because obviously there's unfair dismissal, general protections claims. But getting advice about when that's appropriate, because the shift now is if you keep a bully in a workplace where conduct is substantiated, then you've got a psychosocial risk from other employees that might say, well, knew the bully was there, I reported it, didn't investigate it, you did nothing about it, you took no disciplinary action, I've had to continue working with this person and now I've sustained an injury. So fine balance there as well.
Well, for our remaining moments, we'll open up the metaphorical floor to questions. We had one come through whilst we were talking, and this one reads, it seems like things are getting harder for employers, does this mean we can't performance manage employees in case it's seen as bullying and harassment? And thank you for that one.
Yeah, I've had that come up a lot. So, people are saying, oh, people are so precious now. We can't do anything. We can't say anything. They're going to bring a claim, and employers and organisations are fearful. I'm not fearful at all of managing employees where it's appropriate and issuing disciplinary conduct, again, where appropriate. So, the way that organisations can protect themselves to manage employees is make sure that they've got an appropriate employment agreement in place, the terms are clear, the roles clear, KPIs are clear, so that if there are performance issues, they can obviously be counselled, spoken to about it, and if the performance doesn't improve, disciplinary action can be taken. I would always recommend advice before doing those sorts of things because of the sorts of claims that come. But we don't need to confuse, issues of complaints and performance together. We don't need to conflate them. There are two separate issues, and as long as both are appropriately managed and dealt with, then in my view, they're often two separate issues.
And Christina Bianco, what if you see an employee who's crying at work? You've never seen them cry before, but you're concerned that it could be a personal issue. Is it appropriate for the employer to go tap on the shoulder and ask if they're okay?
Yes, it is. Something that I always do. It's important because it may not be personal, it might be work related, it might be both. And obviously a conversation is delicate if it's personal and you're there to support them. There's an EAP program if they need that as an external support, but we do prefer to address that very privately, and then we can see if we can support that employee.
I think it's important too to document that. So even if they say, oh, look, it's a personal issue, I had a fight with my husband this morning. Okay, that's fine. Happens to all of us. My husband's not watching, so but you should document that and say, on this day I spoke to this person, it was a personal issue or it's related to this, so that if you ever got a claim later on, oh no, that was work related, you're like, no, we actually checked in and we've got supporting evidence, and you don't have to provide those notes to the employee, but just have some internal documentation.
Last but not least is Christmas party season, which can be a lot of fun, but can also be absolutely treacherous when it comes to employment law. Let's say that something happens at a Christmas party where one staff member, let's say they're a more junior member of staff, is sexually propositioned by a more senior member of staff. That junior staff member, rather than telling their direct line of report because they don't feel comfortable to or going straight to HR, instead goes and tells another employee who is either on the same level to them or perhaps slightly higher. What is the duty of the employee that they report this conduct to? Should they go tell, or if the employee has said to them, no, don't tell them, I just want to talk about it, but I don't want this to go anywhere, what should they do?
Well, we all have duties to each other in the workplace to make sure that we've got workplace, safety, that the workplace is safe and free from workplace harm. So I think that goes back to the training of all staff, so that we have policies to say we'll actually have obligations to each other. If something serious is brought up, that employee, should be escalating that to management. So I think it's really important that everyone's aware of their obligations. And in that scenario, and that certainly happened to me before, where people say, I don't want to report this, but I just want to tell you this. And I just say, before you go on, if what you say I think is serious, I am going to have to escalate it. And then I will recommend that you make a formal complaint. Yeah, because otherwise it can put the employer at risk.
Just a question from online. I assume these increased legislated obligations on employers are not retrospective.
That's correct. Yeah, that's correct. So and there has, I think we will see a bit of, they are from the 1st of December, and they've sort of been staggered to give employers have had their heads up. So just really making sure that you're on the front foot for now. Yeah.
We're approaching 9 a.m, so we'll wrap things up there. Thank you all very much for joining us for our last business law breakfast for the year. If you've got any queries, please feel free to reach out to Bianca, Christine and I. Otherwise, look forward to seeing you next year at one of our events.
Thanks,
Thank
everyone.
you.